I'm sorry, what?
You want to bring us back into the meeting? Hand this out.
Yeah. Okay, we will reconvene the August 24th meeting of the Delaware County Land Reutilization Corporation. And everyone has now officially received a signed copy of the letter. So we'll incorporate those in the minutes, that letter in the minutes. Other comments, or?
Do we need to have a motion for that?
Yeah, a motion to approve the minutes with the date corrected and then the letter being added.
I'll second it.
Well, that wasn't a motion. I don't know if.
Oh, I was
yeah,
at the
Gary wasn't
meeting,
there.
so I'm going to have to abstain, or I'm going to abstain, so.
Okay.
So you're making the motion, I guess.
I'll move to approve that
Okay.
with the additions that Mr. Stage made, as well as the accompanying letter.
I'm sorry, what?
As well as the accompanying letter.
Yeah, okay. Dave, you want to second
Yes.
that, or you want me to second it?
Go ahead.
I'll second it. Okay, any further discussion? Let's take a vote, Sarah?
Mr. Benton?
Aye.
Mr. Merrill?
Abstain.
Mr. Schuling, sorry, I blinked.
Yes.
And Mr. Stage?
Yes.
Okay, that's the May 24th. Then we have the June 10th, 2022 retreat. That is a long set of minutes. I don't know if anybody had any comments, suggestions. If not, I would entertain a motion to approve those minutes as well. They also were sent out with the.
I move to approve.
Second.
Okay,
I'll second it.
Dave beat you to it. I did hear you second it, didn't I, Dave?
You did.
Okay. All right, so we'll just do a voice vote. All those in favor say aye.
Aye.
Opposed? All right, that is the June 10th retreat. Then we had two special meetings. The first one on July 12th. And what we've done, we're starting with the special meetings and all subsequent meetings, we're recording them. So just to make it easier for everybody and have a complete and accurate record that's easy to maintain and easy to access. Now, having said that, the actions that were taken during each meeting should be, memorialized in writing, and that's what Sarah has done with the actions that were sent out in the minute drafts. So that's the background of the special meeting minutes for July 12th, and we just had the one action item there, and that's recorded there. So anyway, didn't know if anybody had comments, suggestions, changes.
I'll move to approve July 12th minutes as submitted.
Second.
Okay. All those, any further comments? All those in favor say aye.
Aye.
Anyone opposed? All right, same process for the August 11th meeting. There were two action items. Those are reported on the written minutes, and again, the electronic version are recorded as well and available. So I don't know if anybody had any action or any changes, comments. I would entertain a motion to approve the August 11th minutes as well.
Move to approve.
Okay,
Second.
second. Any further discussion? All those in favor say aye.
Aye.
Opposed? All right, that takes care of the minutes. Next is the treasurer's report.
Yeah, since our last regular meeting was in May, I have copies that just basically summarizes the three meetings. With everybody a copy.
Thank you, sir.
And for the record, the beginning balance on May 1st was $174,216.67. And closing balance, just 7/31 was $158,427.34. The checks that have been authorized are listed on that information I provided you. And I'll make the motion to accept the treasurer's report as submitted,
Okay.
with
any-
audit,
Okay.
subject to audit.
Any further comments? With that, we have a motion. Do we have a second, Sarah?
I'll second.
Dave seconded, okay. We got a motion and a second. All those in favor say aye.
Aye.
Opposed, same sign. All right, treasurer's report is approved. Next item on the agenda is to pay our attorney. Scott Gordon has submitted an invoice. The details are listed in that invoice, which also was sent out with the package. The total amount, it's basically 6 months, I think, yeah, basically 6 months of service is $39.9375. Anybody has any comments, questions?
I have a question. Is it typical that we get an invoice for 6 months' services at a time with a day or two to look at them? Or how's that usually?
Well, I don't think there's been any pattern, because we just don't have that much, legal services, so, I don't know, Scott, you've probably sent them 2 or 3 times a year on average.
Yes, I think originally in the fee agreement, it does note that they should be sent quarterly, which obviously is, this covers 2 different quarters. But frankly, over the last year, I've done it just upon request of one of the board members. Hey, we haven't paid you in a while, and then I've done that. Now, of course, if the board wants more time to consider it, then the board can do that.
No, I'll tell you what, if the agreement is quarterly, then why don't you get them out quarterly and then give us a chance to look at them, and then we can know what we're acting on and
Okay.
understand everything we're paying for.
Okay?
Okay.
With the understanding that going forward, we'll do it quarterly, I will make a motion to approve.
Second.
All right, motion to second. Any further discussion? All those in favor say aye.
Aye.
Opposed? Same sign. Get a check to Scott. I've got it. Sarah's got it all ready to go, so all I have to do is sign it. Next item is the review of the auditor state financial statements. We did have the exit interview discussion, exit conference discussion this morning with the state auditor. It went fine, it went well. We can't discuss it in detail because it is confidential at this point. It's a confidential document, both the audit, the management letter, the financial statements and management letter are confidential.
For a couple of weeks here.
For a couple of weeks, yes. Then they said that they will submit it for publication, and that should be published in the next couple of weeks. And at that point, it is public, and at that point, well, it's a public document, and we can discuss it openly and so on. So anyway, that is the latest. The meeting went fine. So,
Who all was in that meeting?
Mr. Schuling, Mr. Merrill, myself, Sarah, and Karen. Karen's here tonight. Karen was on the call. I think that was it.
And
And
then
there
And
the
there are
state
two state
auditors.
auditors.
2 representatives from the state auditor's
Yeah.
office.
Kim
I
Blake
can't remember
was the
their
audit
names.
manager.
I can't, don't ask you their name.
Yeah, I know.
Yeah, Tori something was the gentleman who did it was the manager, or the senior, I'm not sure of the title. So anyway, that's where we are on that. Now, next we go to the demolition grant. Unfortunately, we still have not heard from the Ohio Department of Development, other than an updated amendment, or updated amended agreement, which we addressed and got approval to sign, and was signed and submitted, I think on the 12th, right after our meeting, I think we did it. So it's the amended agreement has been sent and acknowledged as having been received. We do have the IGA to approve. We have the subrecipient agreements with some updates. We have an invoice to approve, although it's not necessary to be paid just yet. And then I did get a communication from the Ohio Department of Development saying they need the supplier ID and the uniform employer identification, I think is what it's called, or unique employer identification. And we'll get both of those, but those have to be created before they can start processing payments. But I think we have the one, and I don't think we have the other, and we'll get those in the next day or two. So that's, again, I assume you guys haven't heard anything. Dave, you heard anything from Land Bank Association?
I'm
or
not
anything?
their main contact, so no, I wouldn't.
Again, we submitted this information in February, and here it is August, and crickets, so.
Well, you know, the thing that concerns me is that we're now, I'm not gonna remember the exact dates, but it's late in the May 23rd, I think it is, that we can submit, or that we can incur costs, and then we have to have them submitted in June, and we've already lost
Yeah,
3 months.
I agree. It's-
And we
yeah.
still have, you know, no way to initiate these projects, and that's concerning, because with the status of, you know, being able to get construction resources available to help us, or to help the beneficiaries, and winter's coming up, this is gonna get exciting before.
And
it's
with
over.
everything going on in the central Ohio area, construction's got
Well,
to be an issue.
exactly, I mean,
Yeah,
you know.
I completely agree. I mean, I wish we had some way to break the logjam, but I don't think any counties have heard anything. Dave, I don't know if you've heard.
If they have, I haven't heard.
Yeah, I don't sense that anybody's hearing anything.
I haven't heard a thing.
They have to move that deadline back. I mean, they'll have
Well,
to.
they don't have to do anything.
I know, they don't have to, but
You would think they would.
you would think they would, because, again, they acknowledge, they've said, don't call us, we'll let you know. They
Right.
made it clear.
You know, and they put us on notice that, you know, nothing can happen that they're gonna be responsible for funding until they advise us that the projects are approved.
Oh, yeah, they
That's-
made it very clear about that.
Quite,
too.
I think that's what we're waiting for.
Yep.
I think most of everything else is in place. The subrecipient agreement, I have a question or two, you know, a comment or two about that, more than a question, but,
Yeah, so
they're
that's
putting,
really.
they're putting us in a difficult situation here is what they're doing. I don't know if it's intentional or not, but they are.
Yep. Well, and those are the two topics that we really need to just finalize, if you will, the IGA and the subrecipient agreement. So, and unfortunately, Dave Eflin's not here, but he and Diane did a really nice job of pulling this together. It has been approved by their city council. It was approved last Monday. And it's, you know, so from their standpoint, they're ready to sign it. I know, Scott, you took a look at it. I think you had some minor changes. If you want to go through those, Scott, maybe if you could do that?
Yeah, I'd be happy to. I think you're right that the city council has approved the proposed IGA. The city attorney, Natalia Harris, and administration in the city are the ones who presented this to us. Frankly, I think they took a lot of this from just old IGAs that have been
Sure.
engaged and then catered it, updated rates of, and what parties might be involved. And on page three, I noted it says that the city of Delaware is not gonna request compensation related to its own project. I felt like you might as well go ahead and identify what that own project is. They have the two buildings on Spring Street that they anticipate, that have been incorporated in the application, so I added that just for clarity. On page 4 in paragraph E, given that I think Diane Gunther and then city officials have already done quite a bit of work, I thought it would benefit us to just make it clear that because of the retroactive dates and all of that, I didn't want any unforeseen argument about that they might be able to be paid for any services rendered up until the date of the agreement. So I noted it that any services that the land bank may benefit from would be compensated from the date of this agreement forward.
That's my understanding, just based on conversation with Dave.
That's what I thought so too, but I just didn't,
Yeah,
I
good
wanted to
to put it
avoid
in
any
writing.
a disagreement. And then in paragraph G, I noted just a change in some wording to make it a little more clear, or to also incorporate that the city's not only protected from that, but we are as well.
Okay.
Those were my only comments.
Okay. And based on conversations, actually emails with Dave Eflin, he's said, he acknowledged that the city council has approved it, and that if we don't make any significant changes, you know, Tom Homan would feel comfortable signing it. So I don't view these as significant changes. I don't know if anybody else has different thoughts, but, or anybody, you know, Dave or Mike here, if you guys have comments about the IGA itself, other than the changes.
No, not about the IGA itself, but again, I'm curious, would it be prudent to ask the city, each of the benefiting government entities for each of these three projects, to waive any permitting, inspection, or license fees, since these projects are ultimately benefiting them and not us, not anyone else? That, I don't know what that would save, you know, I don't know, you know, what the financial impact of that is, but it doesn't seem to me that it'd be unreasonable to ask for that as part of the
That's a
agreement
good-
process.
It's a good question. I don't know if there are are there permitting fees to
Well,
demolish?
since we're doing demolition, and since there are going to be inspections at key points that they're gonna have to do, and if I'm mistaken, somebody tell me, you know, I think it's reasonable to ask them. Everything I think it's reasonable to ask them to do, and it is a comment I have for the sub-agreement, is that they provide these services expeditiously. You know, that we don't get in a queue behind 15 or 20 other projects and wait 3 or 4 weeks before we can move ahead to the next one, because, you know, the next step is we already recognize that we're running out of time here.
Yeah.
And I think it's a discussion we can have with them. I don't think it's unreasonable.
Yeah, I don't think they would quibble. I really don't.
I don't think I could be wrong, but I don't think we're talking about a lot of money. I mean, you know,
Probably a few $100s.
and I don't know what the process is. It's the process more than the money that concerns me, is, you know, what happens when these things have to be approved before they can move on to the next phase of these demolition projects.
I think in the case of Delaware City, that'd be considered substantive, so I'd probably have to go back.
Or maybe it doesn't have to be in the IGA, maybe it could be in the subrecipient.
Well, in subrecipient, yeah.
Yeah, I think that.
I don't think the IGA is the right place for it. I think each subrecipient grant, because, you know, Delaware could say yes, and Sunbury and Powell could say no, you know?
So you're okay with the subrecipient?
Yes, I am,
Subrecipient
yeah,
agreement?
I am.
Yeah, I think it's good. Again, I want to thank Dave and Diane for, you know, taking the lead on this and getting it through council now.
To be clear, you're talking about the IGA, right?
The IGA, right.
Yeah, well, they're essentially staffing us, is what they're doing.
Yes. Okay, so, well, let's wrap up the IGA, and then we'll go to the subrecipient agreement. I don't know, any other comments on the?
Just as a courtesy, we need to let them know what changes we made, even if they're not
Yes.
considered substantive.
I'm sorry?
We need to let them know what changes we made,
Yeah, I'll do that.
Oh, yes.
just as a courtesy, if nothing else.
Yeah, I'll send it to Dave and just tell him to sit down with Tom Homan and say, is this okay? And I think it will be, and at that point, I'll sign it, assuming, again, we pass it and give me the authority to.
Yeah, I would think any motion should just include that in substance this, if there's any just typographical or grammatical type of changes, then the board would approve some representative to enter into the IGA, but anything more substantive probably has to come back to the board to consider.
Okay. I would entertain a motion to get well, I guess the vice chairman couldn't sign it because he's conflicted, but I would entertain a motion to have me approve, sign the IGA as amended after discussion with Dave Eflin to make sure that the administrative changes we made are okay. That was a long motion. except I didn't really make it. Did you get that, Sarah?
Nearly. Give me a couple seconds.
You want to read it? Make
Yes.
sure.
In the matter of approving the intergovernmental agreement with the City of Delaware and Chairman Jeff Benton signing the agreement as amended with administrative changes. Does that sound
Second.
decent?
So he seconded
Yeah,
it.
oh, I guess I'll consider that my motion, so I'm fine making that then. So, normally a chair wouldn't make a motion, but, okay, so, motion sound okay, let's take a vote, or we'll do a voice vote. All those in favor say aye.
Aye.
Opposed, same sign? Okay, now we can go on to the discussion of the sub-recipient agreement. And I think those are good points, Dave, to add in the language in there about inspections, demolition permits, any related fees should be borne by the local jurisdiction, you know, the city or village or township.
Yeah, and I'd also like to get some language in there that asks for expeditious turnaround, whatever expeditious is.
That's gonna be a very subjective thing.
It is, unfortunately, yes.
Yeah,
But, you know, if we can convince them that we need to move to the top of the queue instead of floating our way up there, it'll help us keep these moving, because we need to do that.
Yeah.
We need to keep
What is
moving.
something along the lines of, we ask that you, in a quick, timely fashion, you make appropriate approvals, whatever you have to do to ensure a quick turnaround on this project.
Yeah,
It's about as good as we can do, you can't,
right, I think we make it clear that we're not asking for any special dispensation, we'd just like them to keep them moving.
yeah.
yeah. Yep.
Did you,
You want to take a stab at that, Sarah?
I'm trying to wrap my head around it for a second. Hold on.
For what it's worth, this draft that you have before you in the top of page 2, it could be broader to include the comments here by the board, but it does mandate that the eligible applicant understands their specific and strict timelines and reporting expectations included in the grant agreement, and that the eligible applicant must diligently, consistently, and it even says expeditiously, document their efforts, communications, expenditures, and report any and all relevant information to the land bank upon request and in conformity with the timelines and provisions. But I agree with you,
Well, yeah,
that's more reporting and communication as opposed to.
the applicant's not the same as the local government entity that is inspecting, permitting, signing off, whatever.
Right, well, so it's my understanding.
Maybe we take the approach, ask them if they would consider being a third party to this.
I was gonna say, because the sub-recipient agreement doesn't necessarily include the city of Powell, so they're not,
Right,
if
but
they
it,
don't own the
but
property,
it
they're not
could,
really signing.
it could include the city of Powell to the extent that they're a key player in this. It could include the city of Sunbury to the extent that they are, and it could include the city of Delaware to the extent they are.
Yeah, of course, if those entities are willing to.
What they can do is say no,
All right.
but if we don't make that attempt, we don't know. Again, frankly, I'm concerned that if we don't get an extension out of this, these things are gonna have to move. Particularly if we encounter any unexpected contingencies, like asbestos or anything we didn't expect to find anyplace.
Yep. Yeah. Yeah. So, how could we change the language in the agreement? Scott, what do you think?
Well,
You don't have to come up with an answer now if you need to,
Right.
because it's, something I think that needs to be reasonable but enforceable.
to the extent that the units of government are gonna be the parties to here, I think that request, I can add some provisions in that's what they're agreeing to
Well,
do.
but are they the parties now, though? That's what I'm confused about. It seems to me that the parties are us and whoever the sub-grantee is, and that's whoever is the end user of the property.
Right, I agree with you, but.
That's not the local government entity.
Right, and so at least the 5 projects I'm aware of, the city of Delaware actually is the end user.
Are they?
here.
Okay.
They own
Because they own that property.
There's 2 properties.
Powell and Sunbury, Powell is not,
Is
I don't
not.
think, and Sunbury,
Sunny V is not.
right?
They would just be working with us as well as the city of Powell. Sunbury, I can't speak to, and then I thought there was one other township, is it,
Scioto.
Scioto Township?
I don't think they own it.
Okay,
I think they have control of it. I don't know exactly what legal form that takes, but.
right.
You know, I think this gives us a chance to at least have conversations with them while we're waiting to hear from the state.
I mean, to the extent that the board wants me to say that both parties, us and the eligible applicant, commit to making that request of each unit, local unit of government, I mean, of course, we could do that, like Mr. Stage said. You can always ask and push for that, and the worst they say is no. So, I can include that intent and that provision in there, if the board would like me to.
Do we need a resolution for that, or do we just need to ask Scott to work that in?
The challenge is if we delay it, then we're gonna have to have another meeting to approve the agreement, unless we approve the agreement according to the amendments that Scott makes. Again, I just don't wanna have to keep scheduling meetings.
I'm taking a stab at this, I'm not saying that this is the right way to do it. In the entities that are not controlled by Delaware City, we just include a statement that we send this document to that entity, township, whoever it is, and say, we encourage you to do everything in your power to expedite this process to ensure the success of
Timely success.
timely success. Something generic like that. There's no real commitment, but if you read that, I think you'd want to react to it positively because it's good for your local entity, whatever it is. I don't think we can do much more than that,
I
but
don't
that
know.
that might be enough. Just a thought.
I think we just make the ask, however.
So if we could just include a statement to that effect, Scott, you could probably wordsmith that a little better than what I just did.
I'll do it.
And with that understanding, you go ahead and proceed,
I'm fine with that.
and is that fair?
Fair.
I like that.
And we want to put in the agreement that they will either waive the permit, demolition fees, inspection fees.
You could say we would encourage or something along that line. You can't,
Well, we just ask.
yeah, that's what,
Yeah.
but that's what we would encourage is a positive way to ask, I think.
Yeah, and again, the jurisdictions I've spoken to, they're very anxious to get these things done. It's not like they're gonna wanna drag their feet, so if they have to eat some
But I think
inspection
today's
fees-
point, just putting it on the radar by, in some form, making them aware of it, it's more
Yeah.
likely they're gonna say, yeah, we can do that.
Right.
If we don't put it on the radar,
Yep.
it's probably just gonna follow the normal process.
The thing is, we don't blindside them with it. We let them know up front that, this is an ask that we believe is a reasonable consideration, and
Yep, okay. Got that, Scott? So you'll do both of those then? All right, okay. Well, is everybody okay then to approve it with those, subject to those changes?
so move.
Okay, second? Is there a second?
Second.
Okay. Okay, all those in favor say aye.
Aye.
Opposed, same sign? Okay. Again, thank you, Scott, for taking the lead on that, and that's an important part of the process here. Last item is SFM. Sarah's been working diligently with SFM, trying to get a small increase in coverage. Basically, it indemnifies the land bank for any, malfeasance, theft of the funds that are being transferred around to pay the contractors or pay the subrecipients. And we did get a quote from SFM, which was sent out, I think it was sent out, wasn't it?
It wasn't an actual quote, it was in the email, so I forwarded the email to the
Okay.
board.
Yeah, and the interesting part is they're saying we can write this policy now, but we don't have to because it doesn't apply until you start doing cash movement. So I guess what I would suggest is rather than having another board meeting just to approve the invoice, approve this quote, assuming it comes in at that number in the final invoice, and approve paying it when the cash starts to move, so we don't pay ahead of time. Because we could be here another 2 or 3 months.
There's no reason for the clock to start running until,
Yeah, that's what.
and you may, for the record, you may want to state the number.
And
It's-
the amount of coverage that we've requested complies with ODOD's requirement.
I believe it does. I sent the whole,
Yeah, you
the
sent
first
the whole-
agreement to Brian Smith, who is our consultant or agent for that, and he read through it and understood that this is what we need to have covered, so.
All right, so moved.
Yeah, it's $542, so not a huge amount of money, but, okay, so
I'll second.
we're approving it subject to going into effect when being paid, when the cash starts to move, which again, could be next month, could be 3 months.
So we're approving it, that'll come into effect when we have something to cover.
Yeah, exactly.
And I apologize, I missed who made the second on that? Gary?
Gary
Sorry,
did.
thank you.
Okay. Any further discussion? All those in favor say aye.
Aye.
Opposed, same sign. All right. Tax foreclosure update, really not a whole lot to report. Got an update from the prosecutor's office, same 4 properties. The main one, which is the next topic, is the Lusby property. There are 3 others that are in various stages of the foreclosure process. So we'll move on to the Ashley property. I talked to Jim Nelson after the last board meeting, who, Jim is the mayor of Ashley, and he said that, you know, obviously they're anxious. This is a real nuisance property. It's been that way for a long time, and they finally got it through the process, and now the state owns it. He said that he hasn't been approached by one builder who wants to buy the properties, but he didn't want to pay the tax lien, $17,000 or whatever it is. He wants to buy all 3 parcels and put on 2 houses. And I know Mike, I think Mike Ringel is here from the auditor's office. Mike and I have had a couple conversations about doing an auditor's auction on these parcels, the 3 parcels, basically one property. And that's where we are. Mike, I don't know if you had any comments. I know you've had some conversation with other folks who are interested in the property as well.
Yes, Mike Ringel, Delaware County Auditor's Office. We had one woman who stopped by the auditor's office before the Lusby parcels had been foreclosed on completely. She expressed an interest in acquiring the parcels. She apparently does turnarounds for dilapidated parcels. I recommended that she reach out to the Land Bank Board and that I would keep her updated once the auditor's office decided it was going to conduct an auction on those parcels.
Okay.
Do you have a rough date when an auction would take place?
It would take at least 3 weeks for notice to be published. You have to have notice for 2 consecutive weeks, and then it would take roughly another week to get the notice to the paper to have them plan to run it. I believe other than that formal notice process, the sale could be conducted quickly thereafter.
And you see that happening shortly thereafter? Is that your expectation, or?
Yes.
Okay.
Yeah, once the auditor's office would start the auction proceedings, we would set them to be as quickly as possible after the notification period. That way, the nuisance that the Lusby parcels, former Lusby parcels are, could hopefully be remedied.
But an auditor's auction is not the only alternative.
Correct. The parcels could still be acquired by the land bank or another political subdivision, I believe.
And I think that was the sense of the Ashby Council I'm sorry, not Ashby, Ashley Council resolution, that they do this through the land bank, and my conversations with them, while limited, their concern is that the property, I think their first concern is any potential for the property to be acquired by any of the heirs that exist.
I'm sorry, what, Dave?
Any of the heirs that exist, and I don't know if that's even feasible or not, because I don't know what their, you know, what their ability to do something to acquire this property would be. Their second concern would be that the property be acquired by someone then who also doesn't do anything with it and just lets it sit. Because if we waive the taxes, there's no leverage at that point. You know, we haven't gotten anything for it, really, and there's no incentive for them to move. And frankly, at this point, no one knows what it's gonna cost to clean those properties up, A, and or B, whether or not that existing structure is even,
Salvageable.
yeah, if salvageable is the right word.
Yeah. No,
I
I
haven't
agree.
seen it. My sense is that it's not, because, you know, what I've heard secondhand is it doesn't have water service, it doesn't have power service, doesn't have anything. The people are in there stripping it. You know, we don't know what we're gonna get. Or we don't, not, I shouldn't say we, you don't know what's there
Right.
when, at the
Yeah,
end of the day.
the builder that Jim Nelson talked to said that he would just knock it down.
He would-
Clear it out,
he-
knock
he
it
would
down,
tear it down
put-
and.
put two
that-
houses on
that's
the three
probably
parcels.
That's probably the least costly
Yep, yep,
solution.
yep.
And I think I think the Ashley Council agrees that the highest and best use for that property is residential.
Yeah.
Because they don't have any means to, you know, take it over for green space park or anything else. I mean, they just don't have the ability to do that.
Yeah, I mean, if we did go through the auditor's auction, I do think whoever would buy it, assuming we get a buyer, does have an incentive to do something with it, because they own it. They're gonna start accruing property taxes, they're gonna have to insure it, they're gonna have to, you know, put up with the nuisance requests. I mean, so they're gonna, I think they would be incented to address it. And again, why would they buy it if they didn't wanna do something with
I
it?
don't know.
You know, they're just taking on a headache.
You know, I think that that's something that, you know, before we charge headlong into this, it's not like something that we have to resolve today. I think it probably merits, you know, additional consideration. You know, what are the alternatives and what are the options that are available to us? And again, we don't know what it's gonna take to clean that up.
Well, I mean, if we look to acquire it, we're gonna have to do all the inspections. We're gonna have to do asbestos inspection, we're gonna have to do, you know, the other utilities, the environmentals. I mean, we're gonna invest a lot of money and it take a lot of time. You know, that takes probably 2 or 3 months to get through all that. And I personally would much rather have the private sector take on that than us. And I think we have interest. Again, Jim was very confident that one builder was very interested in buying it and demolishing it.
Well, there is another alternative. The Richland County Land Reutilization Corporation might have an interest in doing this. But to do that, it would require, I believe it would require an action by the Board of Commissioners of Delaware County,
To do what?
asking them to come in or giving them, you know, granting them the approval to come in and handle these properties.
So I understand, so I'm not sure why another county would want to do that, but let's say the liability's 10 grand, making up a number. Are they willing to assume that kind of liability? Why would they want to do
Potentially.
that? Do you know why they want to do that?
No, I don't. It's something they're interested in looking at.
Because I think that's one of the issues we have, what would our liability be if we, I don't have a clue.
Oh, yeah, that would be an expensive property to insure. I'm sure you pay a big premium for the jail for a short time.
It potentially could, there's potentially some cost there.
Oh,
And it's costs that, again, if we go through the auditor's auction process and don't get a bid, is there, in the auditor's auction process, can we set what is considered an acceptable bid, or do we have to take $1?
The auditor's office can set a
So we
minimum
can
bid.
set some,
Yeah, that's one of the questions I was gonna ask. Can we set a
we can
minimum?
set some fences around it.
The auditor's office could, yes.
The property has to be cleaned up, it has to be,
So I don't believe we would be able to put deed restrictions related to the sale or qualifications on what could be done with properties that are sold, but the auditor's office is not obligated to offer the property for $1. A minimum monetary amount could be set, say, $1,000 is the minimum bid. And at that point, the auditor's office could take the property off auction and then would just be obligated to continue offering it for auction a year after that,
You have to wait a year. to do it
indefinitely.
again. You said a year later, you have to wait a year to do it again?
At least a year. Well, you would
You
not
have
have to wait. The auditor's office would have to conduct another auction within a year
Okay.
of an unsuccessful sale.
Yeah. So you could,
You know, it's-
later again if you wanted to.
Yes. But I imagine we'd have to do all of the
The
same.
notices.
So the
Public
key is to have a
notices.
minimum large enough to be an incentive to do something, but not so large it discourages bidding. Is that
Yeah.
you know,
pretty
and,
good summary?
and if we can't put restrictions around it, you know, we have roughly $16,000 in unpaid taxes here, round numbers. So if we put, and Mike used the term deed restrictions, but could we put some kind of a requirement in that they get the property to a condition where it can be developed? In other words, they get all the vehicles off of it, they get the old structures raised, cleaned up, hauled off, whatever. Get the utilities, get it ready for it so utilities can be ran in, so that it can be built on. Is that possible?
I don't believe the auditor's office has that authority with the
But
sale.
we could.
If the land bank had control of the property, then the land bank, and I'll defer to legal counsel, but from my previous experience, I believe the land bank could set whatever parameters it wanted to to sell the properties that are in its inventory.
Well, I don't, quite frankly,
We
I
did that.
don't think we should
We did
charge
that
ahead
with
on
jail.
this. I don't think we should charge ahead on this until we better understand what are the alternatives that are available to us, and, potentially what's the cost of that.
Other side I was gonna try to get up there, I did not make it. How many vehicles are on the property, you know?
I'm not sure.
I assume they have some salvage value.
I don't know either.
Yeah.
I have heard,
I wouldn't assume that.
Uh,
I wouldn't assume
yeah, I
that, given the
wouldn't,
condition of the
I have
property.
heard somehand that I'm gonna call them the heirs, because I don't know what else to call them. Some related parties have been putting trailers on there and living in them. David, one of the council members, David, I'm not gonna remember his last name, but David told me that the city, or the village of Ashley, did have conversations with a salvage dealer that entity would remove the vehicles, the old vehicles. Again, I don't know what that process is, because the last thing we want to happen is somebody come in and haul off a vehicle and then find out that, it's been titled, it has some value, and get sued, because they do that. I don't know what the process is for handling abandoned vehicles. I've never done it. Has anybody? Did you ever at the bank? I mean,
Oh, we hold off all kinds of vehicles.
Scott, if somebody has a title to a vehicle of that property, I assume that it would still be owned by that individual, whoever has the title to, regardless whether we auction it or.
I can't quote you what the definition of an abandoned vehicle is, but any kind of property, just like a T-shirt or a sink or a cupboard in a trailer or whatnot, just because it doesn't have a title doesn't mean it can't be abandoned. Or just because something has a title doesn't mean
Can't be
can't not
deemed,
be abandoned.
can't be
So-
deemed abandoned?
Right.
Yeah, I don't know what the definition of abandoned is. It means it
Right.
hasn't been registered for X number
Well,
of
if somebody
years
has
or
a
what.
camper on there, I assume that they're gonna remove the camper because
Well,
they're living
hopefully.
But if they don't, I would presume that when you take the property, you
It's
have the
yours.
ability to clear your property of anything that's on your.
And that requires notice, and then if they don't, then you do something else.
Potentially, I guess, again, I can't quote you, maybe to cover the land bank's own tail, what would we do if we acquired title? But I don't think there's a lot of deference for people that leave those types of properties on that type of real estate.
If I may add to that point, the prosecutor's office actually filed an action yesterday, an eviction action against the Lusbys. There had been some concern that the Lusbys were living on the property, and they had another property that they were also living at, which they were evicted from this morning or yesterday afternoon. So the court, and I believe it's the Common Pleas Court, is currently considering an eviction motion to ensure that there are no individuals currently living or who will be able to live on the Lusby parcels.
on the property we're talking about.
Correct.
Like within the foreclosure action?
This is a
The
separate
property's already
action.
been foreclosed.
Yeah.
So the
Yeah.
properties have already been forfeited to the state, so title is currently in the state's name,
Oh.
and the auditor serves as the agent for the state with
Alright.
respect to forfeited properties.
So they don't have a rightful legal reason to be living on that property because they're trespassing,
Correct.
basically.
Correct.
And they also don't, Dr. Merrill, they also don't have a rightful legal reason to be going in and
Doing anything.
taking whatever they're taking out of that property. But again, the village believes that they're going in and hauling off whatever has value, whatever that could possibly be. I don't know if that's copper pipe or personal possessions or what it is. I just, I think maybe we keep looking at this instead of just rushing into a solution without understanding what's going on, because I just learned some things here that I didn't realize was going on. I didn't know the prosecutor was going to take those actions,
I don't see a downside to going ahead with the auditor's auction. I mean, if we can get somebody in the private sector to pay $1,000 or $5,000 for this,
As long as they do something with it, and don't just leave it sit in its,
yeah, but again,
its
they've
current
got the.
condition.
Isn't
they've
that,
got
wouldn't
the-
that fall under the Ashley zoning?
Well, I think it's zoned. It's already zoned
I'm sure
residential.
it's zoned residential.
Yeah, but I mean, within that, the zoning resolution, I would,
Now, it could fall under some of their inspection, property inspection authority. I don't know. I've never dealt with a property that was noisome, I think was the term they used,
sure.
which was a new term for me, noisome in their resolution, so.
We're kind of darned if we do, we're kind of darned if we don't on this one. The idea of having some minimum, I'm not going to suggest that minimum. And if someone out there in the private sector is willing to pay that minimum and incur the liability, because my fear is we don't know what the liability is. So, and we could spend the next 6 months trying to figure that out.
We could,
And
but
that
we
keeps
don't
it.
have. Go ahead,
That keeps
I'm
it
sorry.
off the tax rolls, and it doesn't put it in a productive fashion, and our goal is to
Yeah.
get these properties back on the tax rolls, so, that's my thought.
If
I'm not suggesting what that minimum ought to be, I don't think it could be a huge number, but at least to show some level of serious commitment that they're gonna follow through, rather than let it sit there, because they're also gonna start incurring taxes.
Correct.
But again, that's up to the auditor, because we don't have jurisdiction. at this
Yeah.
point.
Yeah, yeah.
I mean, it's
Yes.
the auditor who would set the minimum, and presumably they would take our recommendation into consideration, but, this is a nasty property that has all kinds of potential liability and expensive demolition,
This property has a history.
and has a history, and it's, again, I go back to the private sector is much better at doing this much quicker. And if we can get it back on the payroll or the
Yeah, I think, it, you know,
Those tax rolls right away.
if we could get a commitment from someone in the private sector that they are going to do whatever it takes to get this property productive again.
Well, again, I think if someone shows up and bids $1,000 or $5,000, that's a big commitment, because they're taking on huge liability. And they're gonna start paying property taxes on it. They're gonna have to start paying.
Well, I think, you know, I think the liability they're taking on right now, other than the property tax liability, is what does it cost to clean it?
With what, I'm sorry?
Clean it,
Oh, cleaning it?
clean it up.
There could be environmental issues, just nuisance attraction, I mean.
Yeah, I don't,
there's-
you know, I don't think we're looking at huge environmental issues.
Probably not.
You know,
Probably not.
there may have been some oil leaked out of a car, or some coolant leaked out of a car or something, but we're not talking about cleaning up a brownfield here.
I was talking to the mayor, and my recollection, he confirmed it, this is not a new issue. This, go back 4, 5, 6 years ago, I remember getting a call, and I asked, is this the property that I got involved in, and ended up with the health department involved, and they didn't have running water, but, so there's a sanitary issue, and I was confirmed by the mayor that it was the same property, so I think anything we do to get this property moving, in a sense that if there's an individual out there who is willing to take that risk and get the property cleaned up and build on it or whatever, I think everybody benefits from that.
Well, I think they do, you know,
Agreed.
and, you know, but the one, I think at the end of the day, the one tool that we do have, the Land Utilization Corporation does have, is that we could take this property, convey it to a developer, put the title in escrow, pending them meeting certain conditions. If they don't meet them, they don't get it.
And if they don't get it, the liability would fall back on us.
Well, we could take it back.
Good, bad, or indifferent.
In the meantime, we have the liability,
Yeah.
and we're gonna have to maintain it and take all the calls and everything.
Well, something needs to be done with it.
Oh, absolutely.
I mean, I shouldn't say I don't care who, but, you know, in deference and fairness to the village of Ashley, I mean, they've dealt with this long enough, and they're not in a position to do anything. So, you know, frankly, I think that's our role at that point.
Well, my suggestion would be, let's find out what we could sell it for through the auditor's office. Set a reasonable minimum, to ensure good faith effort on their part. And then based on how that plays out, we may end up with it. If we don't get minimum bid. That's my thought.
Yeah, I would
You know,
agree.
and again, I think we owe it to ourselves to have some more substantive conversations with Richland County and see what they're willing to do.
Yeah, again, we could, but that's gonna take a while.
No, it's not gonna take that long.
We could do that parallel. I mean, the auditor's
We
auction
can.
could proceed, and we could have a conversation with Richland.
We can do it parallel.
Again, if they want.
That's a good approach. If we start down the road for the auction and we have another county, you said Richland, and they're willing to do it at some reasonable,
You know,
then I
I'm-
guess we could, from the auditor's perspective, is that a reasonable approach?
Could,
I don't know what their motive is. You know,
I was gonna
frankly,
ask,
I can't
why
imagine.
would
and
they
frankly,
want to
if-
do
I can't imagine
that?
wanting to
if
do
they
it.
get the property moving, I don't really care,
Yeah.
you know?
yeah.
Uh,
Would they would have the legal authority to operate in Delaware County.
I
if
believe
we-
that the Board of Commissioners, the Board of Delaware County Commissioners
Has to
would
grant
have
them-
to have an agreement with them, you know, letting them come in.
Specific to that property?
Yes, and then we'd want to make, I'm assuming they'd want to make sure that they could hold the property in a, you know, tax exempt status like we do. I don't know any reason why they couldn't at that point, because it seems to me like once the Board of Commissioners comes in, if the Board of Commissioners Delaware County were to say, yes, we want you to do this, and seems to me like then they would have all of the rights and authority that they would have if it were in Richland County. Or if it were us doing it, they'd just be doing it instead of us. Maybe they're doing it for us as an agent. Maybe that's an approach, I don't know.
Well, to your point earlier, the goal is to get this property moving or transition.
So I think the
I'd like
first
that
goal
word.
is get it cleaned up so it's not
And-
noisome anymore, and then
and-
get it moving.
And the auditor's auction is a possibility.
It is.
There's no reason we shouldn't let that process begin. And we could always have a special meeting if some
Yeah.
better option
And I,
develops.
you know, again, I think we should
That
have,
fair?
we should have a conversation with Richland County. Frankly, I think we should have a conversation with whoever the potential acquirers might be.
I think there's some question where you could put those parameters on that potential inquiry.
So I want to know what they can do. You know, they come in and take the property for $1,000 and then start accruing unpaid property taxes and decide, you know, I can't make this work and walk away from it. We're right back where we started.
And, but the problem we have is we don't know the liability, the risk. And you would assume that a private investor is going to do appropriate research,
Hope so.
so.
The one that Jim Nelson mentioned was familiar with the property, so he knew exactly what.
So he was comfortable with this particular person?
Yeah,
Okay.
yeah, he said a good local builder, wanted to put 2 houses there, knew the property, knew it well, was very familiar with the problems.
So what would the process be if we were to reach out to Richland County and ask them, hey, what do you want to do with this and why do you want to do it? And what,
Do you-
Well, I think
I
first,
mean-
I think first we have a conversation with them.
Yeah, do you have a
To
contact?
get
there?
their, you know, are you really serious about this and can you do this? And if they can, then I think we probably know what the process would be to bring them in.
I can't imagine wanting to do it, but.
Well, they're interested.
Okay.
my first thought is what do they know that we don't?
Yeah.
And why would they want to do that? But if they're willing to do that, I can't see why we wouldn't do that. But I can, again, just thinking out loud in action of the Board of Commissioners to say, hey, in lieu of the Delaware County Land Reutilization
No, we're not there
Court,
yet.
and, you know, I
Well,
mean,
I'll
and
play
I get
I'll
that.
play devil's advocate. Let's say we did that and it works out, and they get involved and find out it's gonna cost X, whatever. And they don't wanna touch it, what happens? Can they walk away like a private investor? Or what can you force them to do to put it in shape, to put it back on the tax rolls? So I'm not sure that problem goes away
You
necessarily.
know, this property is gonna be a challenge regardless of how it is eventually resolved.
So if I understand what you're saying, Dave, do we need a motion to start that process?
No, I don't.
To
think
reach
so.
out
I
and
don't
just
think
talk
so.
with them?
No.
You don't need anything from us to start
The
So,
auction process.
The auditor's authority is already established
Yeah,
by,
and we're not taking an
Statute.
action, a discussion. is
I don't even
an
think we
action,
need to
so.
request that they do it.
So we
Do
just,
we? You just do it,
so we just
right?
encourage them to do it, and
Do we have a,
And,
do you have a contact at Richland, Dave?
yeah,
Okay, so you can
I can.
chat with them and let
I
us
can.
know what they say.
Sure.
Okay.
How about if Mike and I do that?
Okay, that's
And-
fine.
and he did such a great job last time,
Yeah.
I know you're gonna get a great price for this.
This is an even more challenging property.
You know, let's don't dislocate our elbow and shoulder patting ourselves on the back of the CUV because nothing's happened there yet.
I would
So,
think a little sarcastic. I think everybody did that.
But I do think it'll sell. I mean, I really do. It may not sell for more than $1,000, but I think it'll sell. I've heard enough interest, but anyway, okay. So I guess that's it. Any other comments or thoughts, Mike?
Not from the auditor's office.
Okay, all right, well, thank you.
Thank you.
Thank you, Mike. That is it for Ashley. Other business? Anybody have anything else to bring up at this point? I didn't have anything else. All right.
No, no.
Okay.
Move to adjourn, or?
With